that. See that section. How important it is. How well worded it is. Not only the executor is supposed to sign in the presence of the testators, but they are supposed to sign in his presence at his instance. Uske request pe, Baba, please. Any Tom, Dick and Harry is not allowed to come and sign. Baba, मी मारली साईड. चला चला. काय चला नाही. तू कोण? फाळा. पुन्हा. दुसरा बिल पाहिजे मला. असे असतात लोक म्हातारे. तू कोण आला? मधी सही करणारा. So that is why the provision in section 63C of the Constitution Act. It is supposed to be. Now how do you prove this? There is a special methodology of proving such things. At least one attesting witness is required to be examined. Put gaya attesting witness. Bring the other guy. मर गया. Bring the other guy. दोनों मर गए. फिर हाँ? What? No, अरे चलो हरीश प्रश्नच नाही. हे तो बहुत आहे नाही ऐसे. बिल है बिल. ऑर्डिनरी बात नहीं हो. हाँ यस. और एक्सपर्ट एविडेंस. यस यस. So you got it? How important it is? So it is important for you to know what is primary evidence. सिंपल रहता हो प्राइमरी एविडेंस बोले तो क्या? ओरिजिनल. फिर वो कैसा मैकेनिकल प्रोसेस से बनाया होगा. तो अगर उसमें वो एक में से सब 100 बनाया है तो वो जो जिसमें से बनाया है वो प्राइमरी है. ये सब सेकेंडरी होते हैं. फिर मैकेनिकल प्रोसेस असो, लिथोग्राफी असो, फोटोग्राफी असो, काही असो, ते काय फरक पडत नाही. They are primary evidence of each other yet, but they are not primary evidence of the original. ऐसा वो है. Clear? प्रिंटिंग में क्या होता है मालूम है ना? जुन्ना जमाने का, मेरे को अभी का मालूम नहीं है. जुन्ने जमाने का प्रिंटिंग देखा है ना? पेज पे पेज जाता है. Each of these pages, each of these newspapers are primary evidence of each other. But with respect to that, जो मार रहा है छाप, with respect to that, it is secondary evidence. So you must know this. If you know it, then follow the section. Is it necessary to serve notice? If it is a notice, you are not supposed to serve notice. Suppose there is a notice in the case. Not supposed to serve notice for a notice. Clear? So there, the rules are there. Shall I read the rules or you read the rules? But you must know what is primary and what is secondary. 91, 92 also is very interesting. बहुत मजा आता है पढ़ने को. बहुत मजा आता है. And as my friend told me in the morning, and I have also been always telling him this. You know क्या मजा आता है? Every time you read this 91, 92, first you come to know that you don't know anything. I am being honest. आप तो चाहे बिलीव करो या मत बिलीव करो, मैं सच बता रहा हूँ. Every time you study for teaching 91, 92, you realize कि you don't know anything. And I keep on wondering, अरे वो बच्चे लोग को मैंने क्या बोला रहेगा वो टाइम पे. Every time. Not only that, but every time you get some new point. Naturally, because we are practicing lawyers, we go through a lot of mess. So we get something new which is relevant to a case which we are conducting. We become so happy. 91, 92 is that. Not only that, but there are some provisions in 91, 92 which, even in spite of the fact that I have taught this subject for the last 30 years, I don't understand. And that is why my friend has accompanied me. and he calls it की ते खंडाळाच्या घाटात तुझी ती गाडी अडकते. Every time I do not know, I got no answer to those questions. And even today I am in that same quandary, but I am not going to let you know what is my problem. Because you will suffer that problem thereafter. I don't want that to happen. What is 91 now? See, ये 91 and 92 जो है ना, corollary है, देखो, ये समझ के चलो. बहुत ब्यूटीफुल सेक्शन है. किसके बारे में? Terms of a contract, grant or disposition of property are reduced to the form of document. No evidence. No evidence to do what? To prove the contents of the terms of that particular document, but the document itself. And I'll tell you again at the point of repetition and honest truth. We were wondering कि अरे ऐसा क्यों है 91 में ऐसा क्यों बोलता था? No evidence. No oral नहीं, no evidence except document itself for proving. Or if that it is required to be proved by secondary evidence, then secondary evidence permissible है. रहेगा तो जो notice bitis देके सब. But document itself for proof of the contents of a document. And what an intellectual answer has been given. I must tell you this answer. My friend has given that answer on the way. तो ईरानी यार ऐसा हो सकता है ना? It can happen. There is a sale deed. You don't want to prove the sale deed. So what you do? You make another document. आम्ही ते सेल डीड आम्ही एक्झिक्यूट केलं होतं, दोघांनी सही करायचं. Prove that document and not this document. This is where 91 comes in. Not allowed. No evidence. It's a no evidence rule, except the document itself. So if there exists a sale deed which you want to rely upon in respect of its terms, sale deed or grant of property, whatever it may be, bring that document before the court. प्राइमरी तो प्राइमरी, सेकेंडरी तो सेकेंडरी, पर वही डॉक्यूमेंट और दूसरा डॉक्यूमेंट टू से के ये डॉक्यूमेंट हुआ है नहीं चलेगा, क्योंकि 91 का बार आता है. दिस इज द ब्यूटी ऑफ 91. आई रीड द सेक्शन नाउ. And in all cases in which the matter is required by law to be reduced to the form of a document. ये दोनों भी. Either it is reduced to document or where law requires it to be reduced to document. No evidence. No evidence shall be given in proof of the terms of such contract, grant, or the disposition of property or of such matter, except the document itself, or secondary evidence of its contents in cases in which secondary evidence is admissible under the provisions thereafter. कितना मास्टरपीस है ना? आफ्टर 30 years of teaching, आज रास्ते में हमको इसका आंसर मिला. इट इज नॉट नो ओरल एविडेंस. ओरल बिरल की बात नहीं चल रही. नो एविडेंस. वो जो डॉक्यूमेंट प्रूव करना है ना, जिसका टर्म्स ऑफ अ कॉन्ट्रैक्ट और डिस्पोजिशन ऑफ प्रॉपर्टी, ब्रिंग द डॉक्यूमेंट फॉर द कोर्ट. डोंट ब्रिंग एनी अदर डॉक्यूमेंट टू प्रूव that there exists that document. It shall not be allowed by 91. Clear? कितना masterpiece है ना? It took 30 years for me to understand this proposition of law. And I'm thankful to my learned friend for that. full credit goes to him. This was the Khandalaka Ghat from every year chalne ka. He was also a teacher in Symbiosis. I was a teacher in Symbiosis. आणि ते सुरू व्हायचं काय ते कसं काय असतं. Today we got the answer. Clear? 91. Now you see the exceptions and explanations are, there are two exceptions, very simple. This is कि when a public officer is required by law appointed, उसका appointment prove करने की जरूरत नहीं है. The very fact that he acts as a public officer is sufficient to prove the fact that he has been the public officer. Next one is, will is admitted to probate. You prove the probate, not the document itself. Simple. Probate का meaning क्या होता है? यही, हाँ. Certified copy of that will is the probate. Therefore, probate के लिए exception दे दिया है. दो exception है, बाकी कुछ exception नहीं. Okay? These explanations are not necessary. And then you see, the last example is important. See the example E. A gives B receipt for money paid by B. Oral evidence is offered from the payment. The evidence is admissible. A gives B receipt for money paid by B. This example was another heart failure for me. But I got the answer. I will answer. Don't worry. What is the answer? Do you know? अरे receipt है यार. वो contract है क्या? Grant है क्या? Any other disposition of property है क्या? नहीं ना. किसके फिगर करते हो? वो receipt है. Receipt means what is orally stated is on paper. It is not a contract, grant or other disposition of property. Receipt है still. That is why oral evidence is allowed to show whether money was paid or not. Clear? If I can answer, you have to answer them. Follow.
Sir, if there is a document which is already executed between the parties, that document, out of some reason, is destroyed immediately after the execution. And now the parties want to record the same document in some other terminology, a findings of deed of confirmation or something. In such cases, how will we rely upon, or suppose if the bar of section 91 arms me from relying upon this document in case of dispute, then it will, it will frustrate the purpose.
No, it won't. It won't. I'll give you the answer. My answer. I may be wrong. And I will request Mr. Digay to give answer or anybody else to answer. My answer will be like this. You will have to do the document all over again. वो स्टैम्प भरने का नहीं भरने का उसका आंसर मेरे पास नहीं है. वो Digay को मालूम है. उसका सब लिखने का फिर. ये डॉक्यूमेंट किया था, ऐसा हुआ था. तो वापस हम पूरा स्टैम्प भर के वापस डॉक्यूमेंट कर दे. वो स्टैम्प वाले को बोलने का डिस्ट्रॉय हो गया, तुम्हारे से हाथ से डिस्ट्रॉय हो गया, व्हाटएवर. बाहर अंदर गए तुम्हारे स्कूल. Good question. But that is the way I would go about it to solve the 91 problem. Now what you want to say is that disputes arise, then what? Then suffer. Nobody is against you.
If the document is registered with sub-registrar's office, the copy can be obtained from there.
No, he said गया सब गया. उधर से भी गया, इधर से भी गया, सब जगह गया.
It is only executed, not registered.
हर जगह I will change हो रहा है आप ये चीज़. But I will request my friend if you want, please answer this question if you can. I am being most obliged. At least after about 10 years of teaching the Evidence Act, I came to understand. And I will tell the name of the lawyer who told me about this.
Master lawyer of the
Huh? No, the one whose chamber. No, the one chamber was there next to the canteen. अपना इसका canteen तो अभी इसका बेटा चला है, उसका बेटा का वो मुझसे बड़ा good friend. We have some common interest. common interest I can forgive Divya for laughing. I'll settle him on the way, don't worry. But I cannot settle John. He was the gentleman who told me about this particular provision. 92 में बहुत beautiful provision है. मैं आपको बता दूंगा. You don't have to suffer for 15 years that I suffered. बहुत अच्छा बात है. You know, when even if you are teaching, you don't catch it. Fundamental difference between section 91 and 92 is this. As far as 92 is concerned, who are the persons against whom 92 is applicable? Only parties to the law. That is not the case. The bar under section 92 is applicable to the party. That is the section. See, when the terms of any such contract, now you see, such contract means the contract which has been already proved according to section 91. इसकी बात चल रही है. Terms of such contract. Grant or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section. No evidence of any oral agreement. देखो इधर अभी oral agreement आ गया. उधर oral agreement की बात नहीं किया. No evidence sir. इधर अभी no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or the representative in the interest for the purpose of contradicting, varying, adding to or subtracting from the statement. ये जो है ना as between the parties to any such instrument, believe it or not, Mr. Pan said one day when I was in his chamber in the afternoon, he was reading a case in which the case was based upon section 92 and he started speaking on this. तो माहिती आहे का Irani? 92 मध्ये असं आहे माहिती आहे का? माझे केस अशी आहे. I knew I don't know. सच बता रहा हूँ. 15 साल के बाद मालूम पड़ा कि आपको नहीं मालूम खाली बकवास कर रहे काउंसिल में. मुझे बच्चे को समझ रहा मैं क्या बोल रहा हूँ. Because they don't want. I'm giving an admission. Yes. Is that as between the parties. Under agreement grant for the discussion of property. इसमें FIR की बात नहीं आती है. क्या? The document has got to be between the parties only. याद रखना 92 ऐसा है. Now you see there are 6 provisos. These 6 provisos are nothing but sections 93 to 99. I will do the provisos with you. If you understand the provisos, you understand the section very well. As far as section 92 is concerned, when does section 92 awaken? Only if 91 के नीचे प्रूव हो गया डॉक्यूमेंट तो ही. पहली बात 91 में डॉक्यूमेंट होता है ना, the scope is wider. The document could be a unilateral document also, like a will. 92 में पार्टीज की बात आती है. में लिमिटेशन आता है. ऐसे टाइप ऑफ डॉक्यूमेंट जिस डॉक्यूमेंट के अंदर पार्टीज होते हैं एंड इट इज ओनली 2 पार्टीज जिनको 92 अप्लाई होता है. थर्ड पर्सन को बिल्कुल अप्लाई नहीं होता है. देन दैट वी कैन गिव एविडेंस टू हेल्प विद 91 and 92. Not 91, 92. Not 91, 92. Not 91. 91 unilateral document to be applicable. 92 is only as to the party. Now you see it is simple to follow. If you follow the exceptions, you will follow the section perfect. First exception. You see, you are not allowed to do what? नीड ओरल एविडेंस। फर्स्ट यू हैव टू प्रूव द डॉक्यूमेंट, डॉक्यूमेंट प्रूव हो गया 91 के नीचे एज बिटवीन द पार्टी का डॉक्यूमेंट प्रूव हो गया। Once the document is proved, then it says, भाई साहब अभी ये डॉक्यूमेंट प्रूव हो गया है, now you cannot need any oral evidence to contradict, vary, add to or subtract from the terms of the contract, grant or the disposition of property. Clear? म्हणजे झालं ते झालं, आता पुढे अलाउड नाही what adding, subtracting, varying, कुछ काय पण अलाउड नाही. Now you see exception काय, प्रोव्हिजो बघा. फर्स्ट प्रोव्हिजो किती इंटरेस्टिंग आहे बघा. एनी फॅक्ट मे बी प्रूव्ड, म्हणजे 92 मध्ये नॉट अलाउड टू प्रूव्ह व्हेरिएशन, but here any fact may be proved which would invalidate any document. म्हणजे document was obtained by fraud. Prove fraud, man. You are not touching the terms of the contract, grant or disposition of property. You are not varying, adding to, subtracting the terms. अब रहने दो, वो पूरा डॉक्यूमेंट लेके हम किधर अभी तुम्हारे गले में डाल देंगे, अंदर खाओ बैठ के, कम आउट द टॉयलेट होंगी, ऐसा खिलाएंगे.